I apologize for wasting the court's time by not showing up. I truly apologize.
You didn't show up and you got a warrant out for your
I'm trying to figure everything out. I called up there and they gave me the walk-in days that I can come in and do. To go figure that one out.
Take care.
Take care of like everything that we've been trying to do is to take care of everything. So I'm taking away from my 5 kids because I'm the only person that can take care of them. The dad has to work so he can make the money to take care of them. They don't have like a.
Judge, very briefly.
Let me just say this before we go on. I have no choice but to revoke her 7411 status. Mosher, on your brief or memorandum here, you indicated that Buds LLC and Temersic Erda Namunk were defendants. And I don't think he's a defendant. He was never charged. It's just Buds LLC. So I just want the record to clarify that unless you disagree with me.
No, in fact, the caption is Buds LLC.
Right. Well, but I'm just saying, when you put it in on your memorandum, you included both people.
Oh, okay.
And that's fine. That's fine.
Thanks for the clarification. Yeah, no, I understand. I'm representing Buds LLC.
Okay. So I'm ready to rule unless somebody has something else that they want to say. I heard argument. I asked you to brief it. You have. And I'm going to go ahead and make my ruling unless, like I said, somebody else has something that they want to say.
Yeah, the only thing I would say is I didn't see the memorandum filed Bully Carter before I filed mine. And I didn't do a response to it, but I was noting that in the argument she's pointing out that the NIT had the local road became county roads. And out that shall be county roads in all respects and for all purposes. And I only bring that up because, to then go on and say that, because it's a Class B road, it doesn't have to be posted. I think the fact that the county takes over the roads suggests we don't have any conflict between who's got the road, right? It's the county that's responsible and they should be maintaining signs. On that point, there was one other thing that I think we have a disagreement over. I understood Officer Paul to testify that the sign at Sibley and Telegram will not conflict, that it was the way it is now. And I showed that in the exhibit, the backside of that sign. Ms. Foley Carter stated in her memorandum. At the end paragraph, Officer Paul testified at the formal hearing that the sign at Sibley Road was fake. So I just want to point out how important that is to your plan. And I don't have the method of being able to look at the but my notes were that he said was not flipped.
Okay, thank you. Do you have anything in response?
Just in response, I did just speak with Officer Paul, and he did confirm that it was flipped during the entirety of Ross Lodge, including the same picture.
I don't know. Okay, fair enough. But I'm ready to rule unless somebody has something else to say. Okay, you guys can have a seat. All right, so and I did read this. On March the 18th of 26, Officer Ken Paul of the Downtown Township Police Department issued a citation to the defendant, Buds LLC, for a truck and trailer he believed to be operating overweight in violation of the spring weight restrictions known as the Frost Law. Those weight restrictions went into effect on or about February 16 of 26 and were in effect on the date of the issuance of the citation, March 18 of 26. Officer Paul observed the truck and trailer on King Road near Dix. The truck and trailer were being operated by Erden, and if I'm mispronouncing this, forgive me, sir, Erden Namunk Mercic, and is that how you pronounce your name, sir?
Yes, sir. Yes.
Okay,
sir.
I'm sorry. So that truck was being operated in the area of King. he observed the truck and trailer on King near Dick's. And that area of King being between I-75 and Huron River Drive in Brownstown is in a frost restricted road with seasonal weight restrictions. All 5 axles were determined to be overweight by Officer Paul, and the actual gross vehicle weight was determined to be 72,650, while the maximum for that time, according to Officer Paul, was 43,810 pounds. Citing MCL 247-669, that's known as the McNally Act, the township argues that roads located within Brownstown, like King Road, are county roads, and that the Wayne County Roads Division has jurisdiction over their maintenance, including the posting of signs. Plaintiff further argues that defendants Plaintiff further argues that defendant's argument that MCL 257.7262 requires that appropriate signage is recorded on designated highways and streets, in this case, involving seasonal frost law restrictions, is without merit. The township argues that King Road is a non-designated road and does not require individual posting of signs. Exhibits B and C attached to the township's memorandum reflect that Wayne County has published a listing of roads, including King Road, where the truck and trailer were being operated, is subject to seasonal weight restrictions. There is also evidence that notice of seasonal weight restrictions is and was published on the website of the Michigan Department of Transportation website, the County Road Associates of Michigan website, and Brownstown Township's website. Defendants correctly point out that while Officer Paul cited the violation under MCL 257.724, that the applicable statutory citation should have been MCL 257.722, as that section involves seasonal weight restrictions. Clearly, the defendant did have adequate notice of the charge from the beginning, as the entire hearing without objection involved testimony and evidence regarding a violation of the seasonal weight restrictions. From the beginning, the defendants were aware of the charge and the fact that Officer Paul cited MCL 257.724 is not fatal, and the court will permit the township to proceed under MCL's 257.22. The defense argues that the township's case must fail because MCL 257.726 parent 2 and parents requires that, in part, quotes, any prohibitions, limitations, or truck route designations established under subsection 1 shall be designated by appropriate signs placed on the highways or streets. The defendants argue that appropriate signage advising truckers of the seasonal weight restrictions should have been placed at appropriate locations to advise truckers of the seasonal weight restrictions. Defendant further argues that there was a sign, quotes, flipped. Maybe I misunderstood, but there was a sign flipped over on April 8, 26. That was the photo that you took, Mr. Knight, when you showed us. I believe you're correct, at the pre-formal hearing, on the northwest corner of Telegraph and Sibley. When sometimes I'm getting so old I can't even read my own writing. That's terrible. But at any rate, I think what the defense is arguing here is that's evidence that the county knew they should have posted signage, whereas the prosecution argues, or the plaintiff argues, I should say, that was simply done as a courtesy, and they need not have been doing that at all. So we have this conflict. Was signage required or was it not? And I have to tell you, as well as I think you did on this, Mr. Michael, I tend to think that the specific language here, and I'm going to so find of MCL 257.722 subsection 8, does not require signage if they're published on the website. And at the latter part of subsection 8, it says, quotes, and I'm quoting the statute now, the state transportation department and each local authority with highways and streets under its jurisdiction to which the seasonal restrictions prescribed under this subsection apply shall post all of the following information on the homepage of its website, or if a local authority does not have a website, then on the website of a statewide road association of which it is a member. A, the dates when the seasonal restrictions are in effect. B, the names of the highways and streets and portions of highways and streets to which the seasonal restrictions apply. So again, I cited already, and the reason I think that if there was an intention by the legislature that they also post signage in the appropriate location in light of that language, that they would have done so, that they would have enacted another section of this that is essentially said, not only are they posted on all these websites, they're also to post it in the appropriate locations. And here, since it's stated, the commissions, various commissions here, the Michigan Department of Transportation and the Wayne County Roads Commission and the township published it on their website. I think that satisfies the requirement. And it was incumbent upon the trucking outfit to ensure that they were driving in an area that was seasonally restricted and adjusted the weight or taking a different route. So with that, I'm going to find the defendant, Buds LLC, responsible. Have you calculated the fines on this?
$4,207.50 plus court costs, which I believe are $140.
Let me talk to you two in chambers real quick, okay? Let's go back there right now. Go off the record. You can come back off.
Yeah.
Yeah.
Only one of your left.
Hey, Jim, this set up. After you think so.
You just want me down.
Yeah, I want to see if he can fit under my arm.
Fine.
Yeah. So they just said,
Okay.
She can't be here. Just here. Listen. She's
Okay.
got a show cause it's up there.
Okay.
Problems out house and house ones, you know? Is there any way you can go home? Comes back home?
Yeah, this will be next.
That's what I'm saying, but I don't know
Oh, you want me to? Okay,
if he's got, because I've been.
okay. Yeah, I'll call over there. If you have to go in now.
I don't know if that phone's working, because it looks like it's on. My stuff.
Okay.
Text me. 333 8383.
Okay.
Each. Where are you? Right.
Every few minutes. I guess, I don't know where you want, so I
I'm curious to see what it's like. Okay, say it back here. This is.
Go this way, you just make a left, right?
Stay seated, everybody, please. People advance. Russell. Amber Elizabeth Russell. 26BO2516. Do you have your building inspector in here too, counsel?
Yeah, he was stopped by the train. I will see.
Fine, just let me know when you're ready. Where is Amber Elizabeth Russell?
It's Mason's case. She's not here. He's gonna ask for an adjournment. He just stepped into the Chassen's.
She's not here, what? Oh, it's not up until 10:30. Good morning, Mr.
Good
Graziani.
morning, Judge.
It's not up until 10:30.
Yeah, but he wanted to ask for an adjournment. That's why he brought it in.
And this one I haven't done. Oh,
Okay,
I just
do
texted.
we have anything else ready? People against, Lucina?
Right here.
John or Stephen Lucina, 26W8429221A and B. Your name?
done that if you're not you.
Can you speak good English? No? Do we have an interpreter him coming in on this one, Heather?
Yeah, yes, we do have a interpreter coming in. I believe it's through the services that we have one coming in. They should be here soon. He's scheduled for 9:15.
We have to wait. Can you convey that to him with that Google translator?
If he comes up to the window, yes, we can.
Good enough. Mr. Bazzi, I'm not going along with this. I'm sorry. Call in Mr. Urich. Have a seat. Have a seat. John, direct him to a seat.
Just, right there.
He can't, he doesn't understand us.
Right there, just
Listen. Mr. Urich, please. Can you come on in here, Mr. Urich? Sure. Mr. Bazzi, I need you to stop walking, just get someplace close, if you would, please. People against Nataniela Asmaro, 26W842-878. Your name, Mr. Bazzi?
Good morning, Your Honor. Hassan Bazi, P78448 on behalf of Ms. Asmaro. Judge, I had a chance to talk to the prosecutor. If you're not going to willing to go with it, I believe they're going to reduce it down to impeding traffic. I do have authority to accept that
Come on
responsibility.
in here, Mr. Urich. Your name?
William Uragami, City.
All right, listen. Fashion guy, whatever. I don't feel comfortable. I know this is the prosecutor. They've just wrote a defense lawyer. Not long ago in Woodhaven on Hall, she was upset because I said she thought she was going to get it dismissed. I can't treat people better, just for the record. I got a ticket 8 months ago. And I didn't ask anybody to dismiss it. I just don't feel comfortable. I like this young lady. She's eligible for impeding. Mr. Bazzi, I'm not trying to step on toes, but I'm not going
Absolutely
to.
not.
Yeah, if I make exception for them, I got to make it for firefighters, police officers, unemployed fishermen, and then it's on ad nauseum. So would you rewrite that up as impeding? I'll take that plea and we'll set it up, and please give her my condolences, but I can't go along with that. So I'm going to ask
Will
you
do,
to, seriously, otherwise I got to do it for everybody.
I get it. Fair enough.
So he's writing that up. Are you authorizing that plea on behalf of Ms. Asmaro to impeding?
Yes, Your Honor.
All right, to that charge on her behalf, responsible or not responsible?
Responsible.
All right, I understand. I understand some would do this. I hope everybody understands. I'm not trying to be mean. I just got to do the right thing. Okay. I got to charge her 160. She had one issue back, it looks like, in 20, and I'm going to have the balance due. I'm going to give her till the 17th to pay. Okay, Mr. Bazzi?
Thank you, Your Honor.
160, please accept it to impeding. Have a great day.
Thank you, you too.
Thank you. All right. Kevin Prince. I don't have the file though. I need the file. Do we have Kevin Prince's file, John?
No, we weren't given his file.
I was just given the blue bag.
We got it, we got it. She do things without files. Tell,
Pam was,
Heather, I need the file on,
it's a probation, so Beth was, she didn't need the file, it was the blue back.
yeah, Heather, I'm gonna need the file on this, please, okay, Kevin
would-
Prince? It's 25B 726-159. He's in my sobriety court. I'll start the arraignment without it. Sir, your name. All right, so I saw you this morning. I said I couldn't really talk to you about it because we had a status review. And I went ahead and said we'd handle this when I came in. And what I have is that on June 7th, that you were positive for alcohol on your interlock device as follows. June 7th, 10:26. I'm sorry, Mr. Graziani. I did tell them to set him up with a lawyer. Your appearance?
Okay, John Graziani, attorney on behalf of Kevin.
So you haven't been arraigned yet, but I'm going to go ahead and indicate for the record that they think that you were positive for alcohol on your interlock device on June the 7th at 10:26 a.m., 0.058, 10:27 a.m., 0.049, 10:28 a.m., 0.042, 10:29 a.m., 0.045, 1:15 p.m. on that date, 0.027, 1:16, 0.025, 1:17, 0.026, 1:20, 0.027, 1:21, 0.024. And then the next blow, the next day, you were, according to them, clean. There was 0.000. So with that, that is the charge. If you plead guilty at any time here, or if you're found guilty, you could get 5 days on this. This would be a first technical violation. Do you understand everything I've said? All right. Did you sign, read, and understand an advice of rights revocation of probation form?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. Mr. Graziani, how's he going to proceed here?
Judge, we waive the formal reading and he will be pleading guilty to the violations.
All right, so you want me to enter a not guilty plea for purposes of
Yes.
arraignment? Okay. So, sir, do you understand what your lawyer has just said?
Yes.
Call in, Beth, please. If you plead guilty here, you understand the possible penalties.
Yes.
You understand your rights.
Yes.
If you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge that you tested positive on the interlock device for alcohol on June the 6th, on those dates and at those times. 10:26 a.m., 0.058, 10:27 a.m., 0.049, 10:28 a.m., 0.042, 10:29 a.m., 0.045, 1:15 p.m., 0.027, 1:16 p.m., 0.025, 1:17 p.m., 0.026, 1:20 p.m., 0.027, 1:21 p.m., 0.024. How do you plead to that?
Guilty to that.
Did you consume alcohol?
Yes, sir.
What did you consume?
Beer of non-alcoholic and then 4 shots of tequila.
Non-alcoholic beer and 4 shots of tequila?
Yes, sir.
Was it on an empty stomach, sir?
Yes, sir.
Are you on probation or parole?
Yes, sir. But that's,
On any other report?
oh, no.
Anybody force you to plead guilty? Thank you. I'll accept the plea. I find it to be an accurate plea, made voluntarily and understandingly. The plea is accepted. I'm gonna need to wait for, Ms. Wilds. There you are. Thank you. He's pled guilty. Your name.
Elizabeth Occupation, Your Honor.
All right, let me just make a note here, please. Give me 1 second. All right. What'd you like to say?
Judge, this is a gentleman who's had a long battle with alcohol. He had a case when he was 21 years old, and obviously he constituted a 7 years since his previous one was at the age of 31. He made a mistake. We're asking for mercy. We're asking for no jail time and also continuation of Mr. Prince being in the sobriety court program. He is a hard worker, Judge. He has several children that he's supporting with his fiancee. He works at Empire today as a carpet installer, and he puts in time. He's a hardworking guy. Again, mercy, Judge.
Anything you'd like to say?
Your Honor, I apologize because that's very myself to feel me. There are my kids, girls who dealing with the stress abuse by employer. I just slipped up and willing to do 100% against this right. Just got a bad time.
All right. My concern is, when did he last blown before, he last blown at 8:36 on June 6th, right?
June sixth at 8:36 PM was his last all zeros before he attempted to start his vehicle on the 7th.
What troubles me is that you were trying to get into a car and drive. And I know you weren't of the legal limit, but you can't do that.
Judge, excuse me very quickly. Mr. Prince, although he screwed up royally, was moving a car. He was not driving the car, sir. He was in the driveway. He simply moved it over for a person. They had to get together that night. It was stupid. I don't know how much drinking was done, but he had moved the vehicle. Is that correct?
Yes.
You were not driving on the road.
I wasn't driving to the other side of the driveway at my home.
What do you think?
It does concern me. He wasn't able to move the car. He couldn't, he could not move the car. It was hard with the start. He actually, and that was at, he had to wait. So he attempted to blow into the device at 10:30 in the morning roughly. And then actually spent about, I'm gonna say 3 hours. And then was able to move the car, because he was gonna be under the limit come the 1:21 PM. So it took a while for that alcohol to come out of his system before he was able to even start the car. But during that initial time frame, it was all failed. He was not able to open it, or excuse me, able to start. You know?
What would you have again on the breath or blood result at the time of this drunk driving? It was about a 0.42, right, Kevin? The time of the drunk driving, this, when you had a kid in the car,
Yes.
wasn't it about 4.42?
461.
461. So you're struggling. I get it. You have to be careful. This can't go on. It troubles me that you were still trying to get into a car. I don't care. And I don't care if you were just moving the car or not. I mean, I get it. That's what you're telling me. But you had a 4.6. You were trying to time it. You started drinking after your last blow at 8:36. I'm not going to send you to jail. So I don't want you to get all nervous on me. You're not going to jail. But you can understand why I have concerns. I think that might be the highest one I've ever seen. I could be wrong. There might have been one at 4.8. But you can understand. I mean, when you get to over 4, wow, you could be dead, comatose. You follow me?
Yes, sir.
So let's just do this. He's going back on the sober link, okay?
Yes, sure.
You're to serve. I'm not going to make you do court work. You're going to do 10 hours of community service, and that's to be completed by, and by the way, you know, let me just finish. That is to be completed in this case by June the 3rd. Defendant to be on sober link.
Judge, you mean July the 3rd?
No, I meant June, what did I say? I
You said
meant-
June the third, sir.
I'm sorry, I meant June the 30th. I wrote down June the 30th. My apologies. Defendant to be on sober link device at own expense. At own expense. Until July 28th. And I hate to do that, but I'm really worried about you. You're such a likable guy. You're starting to take shots at tequila. Come on. Let's get this under control, okay? Cost of $50. Can you think of anything else?
He'll need 1 month extension,
No.
on his, phase. And I didn't know if you wanted to address anything with his or his, sobriety court restricted license, Judge.
I know. What, remind me, I don't have to do
You
anything.
don't have to, it's up to your discretion. They will obviously bring that up when he has his DLAD hearing. When he goes to hopefully apply for his full license, but we don't have to in this circumstance.
What's the date I have to extend phase 1 to?
At least until, September 7th, Your Honor.
Why September
I
7th?
have 90 days clean from June 7th when he was positive. That's a scale requirement.
I know, but they're a little harsh with that. I have to do it from today, or can I don't remember. Can I do it?
It's positive, so June 7th.
It was a sober link. I don't have, I mean, interlock. I just can't justify trying to get around that. I'm not going to. I'm sorry. Phase 1 extended until September 7th. I'm not going to take any action on your interlock, but I'm telling you, if this happens again, I'm throwing you out of the program. And I'm talking about especially trying to get in a car. You're saying to move it. I don't have any proof of that. I don't know if you were trying to move it or not. You're a likable guy, but we have a job to do here. That's what I'll do. Thank you very much. Have a good day. Set them up with the sober link. It's got to be at your expense. That's why it's a little worse, too, by the way. Thank you.
Thank you, Your Honor.
All right, let's call Buds LLC, 26B150647. All right, guys, your appearances, please.
Like Parker, Prospect Township.
Edward Nyko, you have Buds LLC.
Mr. Turbish, do you want to say anything? Your name, sir?
Yeah, this is Diamond Dervish. Yeah, I don't have anything to say at this moment.
All right, so I'm just making a note. I found you responsible as charged. I talked to you guys in chambers, said you can either, whatever you want to do. If you want to appeal it, no problem. I'll enter the judgment. Or I invited you guys to talk. She said she usually does it. It's 70%. She's willing to do it now. And now I have a stip form here that I just saw, wherever it is. It says that your client's going to plead responsible to overweight with agreed upon fines and costs of $3,000, correct?
That's correct.
Do you want to do it or do you want him to do it?
I'll do it.
Okay, and you're authorized to enter into this plea on his behalf?
I am authorized.
On behalf of the company, I should say.
Plea on behalf of Buds LLC.
All right, to that charge of overweight, responsible or not responsible on their behalf?
Responsible.
Plea is accepted. I'll reduce the fines to $3,000. They were gonna be what, about, you said you were gonna do 70%, they were gonna be 4,100 and some, is that
It
it?
was something like that.
Okay, so reduced, how long do they need? Can they pay it in a month?
30 days, please.
Absolutely. July the 10th, okay, sir, you have to pay by July the 10th, $3,000, okay?
Okay, will do.
Have a great day. Good luck to you. Thank you very much.
you.
Thank you. Thank you for that, Mr. Nykel. Thanks, Ms. Lady Carter. I've got to take, Mr. Boyd. Do we have a lawyer for Mr. Boyd that he's talked to yet?
Yes.
Where is he? Who is it?
Gentleman in the back.
Was it Mr. Gaith? Mr. Gaith, can you hear me?
Yes,
Oh,
Jim.
hang on.
I'm here for Miss Russell, Judge, on the retained case.
Yeah, I got it.
Wait. Robert Thomas Boyd, 25BA2557. Ms. Foley Carter, your appearance.
Foley Carter, Bassman Township.
Your appearance, please.
Rob Harris on behalf of Bronson Township Board.
All right. And Mr. Boyd, your name.
Robert Thomas Boyd.
All right. Mr. Crawford, your appearance, please.
Morning, Your Honor. I'm Bill Call, Jackson. Federal.
All right. What are we going to do here? Tell me you got good news for me, please. Tell me you got good news for me, please.
You know, like last time we were here, Mr. Boyd was ordered to complete the sentencing order in its entirety. He has made some progress. Unfortunately, if we were to go line by line on that sentencing order, he is not compliant with all but the winter storage of the pumps because we're in June. But otherwise, we're not there yet. We do have updated photos. I don't know if this court wanted to see them.
I do, but Mr. Boyd, I want to ask you a question first.
Okay.
You don't have to do this. We've been going round and round on this since June of 25. Hang on one second. I don't believe I've ever revoked your status either. So I'm almost inclined to have to do that today if I'm going to give you more time. You don't have to do what I'm going to tell you to do, right? I'd like you to call your two sons and have them Zoom in.
Pardon?
Have them use Zoom
Oh,
to Zoom into the courtroom. Will you do that for me, please? Call your two sons. You have two sons.
oh, yes, sir. They work,
I know. They,
12.
so do all these other people. They're Zooming in from work. I'd like you to go out. You don't have to. I'd like you to go out. I'd like you to call them. I'd like to have a conversation. You are forcing me to do something that I don't want to do. You're refusing to take help from people that have offered assistance. Sir, I don't want to debate this. You're a likable man. They've been playing with this for 25 years. I'm frankly to the point where I could be faulted for letting it go so far. You're just not going to listen to me. For whatever reason, I don't think you're being defiant. I dislike judges. I don't like McNally. It doesn't matter to me what the reason. You're just not going to comply. So if I can't get some indication from them that they're going to go over there and help you and understand the severity of this, because I have this belief in my brain, and I could be wrong, that you really haven't discussed the seriousness of this with them. I would like you to go call them.
One works midnights.
I don't care. Good, he's off. He's off.
I can't call him this morning.
What?
He's in bed.
Wake him up.
Oh,
Mr. Boyd,
see what I can do.
get them both on.
The other one, we're not on much talking terms.
You never told me that before. I don't need to know the reasons why.
Yeah.
Call your other son, get him on. Please do that for me. We're gonna give him the Zoom ID. Will you do that for me, John? Give it to him, or Sadie, give him the Zoom ID and have them Zoom in, and I'll pass the case and we'll go from there. I'm gonna ask you to stick around a little bit, please. Thank you. You're gonna go out and call and call them? Yeah, just leave them. Go out and call, you're gonna call them, call them.
Yeah.
Yeah, okay. Robert Earl Curitan. 25B149569A. How you doing, Mr. Curitan? Your name? Okay. You're charged with a violation of probation. Today's the date scheduled for hearing. You had no prior technical violations. I placed you on probation on March the 19th and 26th. The charge, this is a trespass that was taken under section 771.1, and I have 3 violations. Failure to attend the court work program on May 16 and 26. Do you understand that charge? Count 2 says that you failed to pay your fines and costs as ordered. Violence owing 670. Do you understand the charge? Count 3, you failed to provide proof of completing 16 hours of community service by May 15 of 26. Do you understand that charge? Yes. If you plead guilty or if you're found guilty, you could receive 15 days in jail. Do you understand that? Did you sign an advice of rights and read and understand that advice of rights revocation of probation form? Yes. If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial. Do you understand that? You do have the right to a lawyer. I think you should get one. I'll supply you one at public expense today. Would you like one? Yes. I'll give you one. Not guilty, please entered. I'm going to set this for, I'm going to let you go out and talk to a lawyer. Who's this going to be?
I'll get the Grazian.
Okay. And then you'll go meet with Mr. Graziani and you'll come back in front of it, okay?
Okay.
Good luck to you. Thank you. Have a great day. We'll see you back here in a few minutes. Doing his file and everyone the interpretive gets you around the scene if you would. Amber Elizabeth Russell. 6B02516. Is she ready on that?
Good morning, Judge. Mazen Gaith appearing on behalf of Ms. Russell.
This isn't scheduled for 10:30 until 10:30.
Judge, I was just retained on this case on Saturday.
Oh, you retained? Did you
yes,
file an appearance? Yes,
I
you
did this morning. I was going to ask for a short adjournment, Judge, just so I can get my bearings on this and hopefully make more
No
informed.
problem.
Plea.
She's so you're going to let her know, though, right?
Yes, Judge.
All right, good enough. I'll just make a note. You were just retained, and request to adjourn granted. You got a date for me, Heather, in a week or so? Is that enough time?
I was going to ask for July 8th, Judge, if possible.
I'm not.
You're
here.
not here.
Oh, okay.
I don't want to go that far. I mean, why are we doing it that far out?
Are you here on the 25th, Mazen?
I'm not, but I can be.
I don't want to. Is that the next time you're here? Is July 8th?
Yes, because I'm here on the 24th, but I've got a conflict, so that date I need to swap out with somebody else. So yeah, the next date, Judge, I would be here is the 8th.
All right. I can't do the 8th.
I can do the 25th, Judge. It's not a problem.
I'll let you zoom in if you want.
Okay.
Sorry.
I'll adjourn this to June 25th at
8:45, does that work?
8:45, can Zoom. I'd rather she be here in person if you can make that work though, okay?
Absolutely, Judge.
Thank you.
Thank you,
Will do.
Judge.
Thanks. Jacob William McEntee, 26 W841716.
Good morning, Your Honor, you and your staff, Ryan Berry, P76788, appearing on behalf of Jacob McNally.
Your name?
Jacob McIntyre.
Boy, they didn't give me these deals when I was a lawyer, Mr. Berry, you know what I mean? He's going to plead to a civil infraction, section 110-106, public nuisance.
Yes, Your Honor, no plea response.
They're going to dismiss the MDOP.
Yes, Your Honor.
And it says victim consulted has been paid full restitution of $270 $270. Prosecutor requests a $500 fine. That's agreeable to you.
That is agreeable, Your Honor. We would just ask the court, for some time to pay if the court would be so gracious.
Mr. McEntee,
Yes, Your Honor.
you have no idea. You should go play the lottery or something tonight. No, seriously. You know, you're getting away with something, striking and breaking victims' windows to vehicles. I don't like this. I don't like it at all. Can you at least tell me that he has a clean record?
As far as I know, he
He
does.
had one that was taken under
But I do see
770.
that there was something.
Dismissed.
Yeah, he just.
Mr. McEntee,
That.
I don't know how your lawyer worked this out for you. You obviously did a really good job. Victim's okay with it, prosecutor's okay with it. I try to never stick my nose in, but I'm telling you, you better walk out of here and realize how lucky you got and then come back here, okay? Because I will remember you. Do we understand one another?
Yes.
Totally and completely?
Yes, sir.
To the charge public nuisance violation under 110-106 of the Woodhaven Code of Ordinances, responsible or not responsible. MDOP is dismissed. Please accept it. $500. Don't come see me again, Mr. McEntee.
Thank you, Your Honor.
Have a good day. Thank you,
Your Honor.
Barry.
Thank
Good day. Thank you.
Was there
Oh, I'm sorry. Well, how much time does he need? Come on back up here.
approximately 30 days, Judge?
Can you pay by then?
Yeah, 100%.
We're gonna make it July the 10th then, okay?
Thank you.
If you need more time, you call the court, we'll go on Zoom, or you come in, Your Honor, before the due date, and I'll give you an extension, all right?
Thank you. Your Honor.
Thanks. Have a good day.
Thank you.
All right, what else do I have? I have Mr. Boyd. People against, Nicole Eckert. Nicole Renee Eckert, 26W842-444. Where is Mr. Zelnick? He's got big shots coming in. They handle the informal.
Good morning, Your Honor. Todd Lanza appearing on behalf of Nicole Eckert. I am standing in for the attorney of record, Ed Zelnick, Your Honor. And for the record, Your Honor, I was here to cover the fountain sentencing as well. I was told that that was adjourned. I believe.
Well, he asked for an adjournment. I signed that.
You know, he said he was going to try and get it adjourned, and he texted me back and said, you know, to cover that as well. So
I spoke with the office this morning and let them know that it was adjourned.
Okay, no problem. So that's all right. So you're going to plead. Let's talk about this one first.
Yes,
we're going to set it. He filed a motion to set aside the default. I said I'd set it for a motion hearing and an informal hearing, or pre-formal hearing, I should say. And you're here. They didn't write down to set aside the default, but by implication, they're indicating they will. Default judgment set aside, and they worked this out where you're going to plead on behalf of the client, or the client's going to plead to impeding with the distracted to be dismissed. True?
That is correct.
And to that charge on behalf of the client, responsible or not responsible?
Responsible.
Okay, I'm gonna accept the plea. Let me see how much bond was posted on this. I think it was there a bond posted on this, Heather? I believe there was, wasn't there?
Let me take a look here, Judge.
We always require that. I don't know.
I'm not seeing one on here.
We got how that got biased, but at any rate, I'll accept the plea 155 and have her pay, if you would, by June the 17th. Okay?
Thank you, Your Honor.
Do you have anything else?
No.
Have a great day.
Great
Good to see you. Take care. Thanks. Bye now. Can we have Lucina up here? Josh, John or Stephen Lucina? This is file number 26W8429218. Mr. Okay, your name?
Good morning. Come on now.
How are you? Raise your right hand. You solemnly swear affirm that you will make a true and accurate translation between the court and the defendant.
I do it.
Sir, tell me your name, please.
Buenos días, mi nombre es John de Lucena.
My name is John Rivera.
You have the right to a lawyer. You're charged with driving while unlicensed. I can give you a lawyer right now if you want one. Would you like a lawyer to represent you?
No,
No, you need a lawyer. Tell me needs a lawyer. Judge says you need a lawyer. I don't know if there's immigration consequences or not. I don't want to know. I don't need to know, but I want you to get a lawyer. You mind getting a lawyer?
All right.
All right, let's get him a lawyer, John, and we'll go from there. You also have a speeding charge. You can tell him 11 to 15 over. So I don't know who we can get, but have them do it first thing if they can, okay? Okay, we'll set him up with a lawyer right now. Okay, whoever we have available. Trinity Amber Elverio. She here? 21W827645.
McNally, Carmen, 273-824 on behalf of the defendant.
Your name?
Trinity Alberio.
So she didn't show up for a review hearing. I gave her,
Gotta go.
I gave her another chance. And I asked her to show cause as to why the conviction should not enter. The conviction was for assault under HIDA, failure to appear for a review hearing, and a violation of law. And a violation of law. Some kind of a public peace offense out of 23rd District Court. Can you tell me what the status of that was, or just how she wishes to proceed here, Mr. Carmen? In other words, I want to be clear. I can overlook your failure to appear for the first review hearing. I don't understand why you didn't appear for the show cause back on April the 20th of 22, and it's a little late for me to set aside the conviction at this point. Anything you want to say?
Your Honor, I believe as far as our case went, she thought she was done with the terms of probation. She didn't get any type of indication from her probation officer or from the court that there was anything outstanding. So I think in her mind, she didn't believe she needed to appear any further because she had heard from anyone on probation for quite a while. As far as you said, is there a warrant showing on the Taylor? I might have overlooked that.
No, let me just see. What happened is I require them to appear. There's still a warrant out of Taylor. There's still a warrant out of Taylor. Well, wait a minute. This is old, April 12th of 22. Can you run the lien on her, Heather?
Yes, Judge. There's not an updated one in there?
There's an old one, unless there's a new one that I'm not seeing.
They should have
but-
done one this morning. No one, when she walked in, there's not a new one? I can do a new one. It's no problem.
The last one that I have in front of me, let me see. Yeah, I don't. Could be wrong, but
I'll do one right now, Judge. No problem.
good. Yeah, I see her traffic record from June 10th. I don't see the criminal history and lien information.
Okay, do one right now.
There was one, like I said, April 12th, 22nd, April 12th, of 22. You know, my concern here is we sent her 2 notices and she didn't show up. And then I entered a conviction for in April of 22. She left with no choice, really. And why didn't she show up? I don't understand. But they had written down, defendant had an open warrant issued January 11, 22 out of 23rd for failure to appear for a pre-sentence report on a public place offense. So it had to be a misdemeanor.
Yeah, I think there's some confusion on my end, and maybe it's my fault. But I'll ask Trinity, explain to the court what happened, Taylor.
So I just went there recently. My grandpa got a traffic stop and I was in the passenger seat and they asked who was in the car and they ran my name and then I got arrested for the Taylor warrant. This was like a month ago and so I seen the judge that same day and they told me I'm gonna be on probation now, but I also have to come here.
I already entered the conviction. Can't go back on it 4 years later. She was convicted of it. If it was dismissed, that might be a little bit different. even though I don't understand her not showing for either court date, because that was the address we had on file. And I told you, if you changed your address or place of employment, you had to notify probation. And you didn't notify probation of any change of address. You made this difficult. What were you convicted of?
For what even?
No, for Taylor.
It was disturbing abuse.
Is there a way you can verify that, Heather? Or you got a lot going.
Yeah.
So the
Give us
warrant's
right
not
there
gonna
with
be
the-
in lien if that was the case. The warrant is
Correct.
not gonna be in lien anymore if she was pulled over recently and it was lifted.
Correct. There was no warrants on her, Judge.
So it's not even on her record. You know what? What kind of sentence did the judge give you there? I'm ready to sentence her. I'm just gonna sentence her on this anew. If you need to look at the file, I'm not gonna do much. I just wanna know what they sentenced her to. The conviction's gonna have to remain, though. It's been on her record since she didn't show up 4 years ago. Not once, but twice. So I'll be glad to just do something here that's fair, and conviction's gonna have to enter them.
Your Honor, I just want to just
You have the
let
first
the
page of
court
the
know,
register.
she does have a 2-year-old son. She is pregnant. She is pregnant.
Can I have the first page?
Full-time, at a daycare, if the court will consider that. Single mother.
Can you hear me, sir? I need a first page of a register, the misdemeanor register. All right, so we do reflect that the conviction was entered in our records, correct, Heather?
Yes, Judge.
Why didn't you show up? I'm not understanding this. You're not being this irresponsible with everything, are you?
No, not anymore. I'm not sure if I didn't get the notice until after it was already too late.
So you understand I'm gonna sentence you. Thank you. Right? On the charge of assault, right?
Yeah.
It looks like she's taking care of everything.
Yes, Your Honor, there's no outstanding probation requirement. There's no blue bag or anything like that. So I think that's where something can use the file with Mike.
All right. You gonna grow up? I'm asking you a question. You're gonna,
Yeah, I already
you
had,
got kids, right?
yes,
You gotta be the adult in the room, so to speak, right?
yes.
Right? I'm gonna charge you $60. I'm gonna get you out of here. I'm sure they handled it appropriately over there. Can you pay the 60 now?
Yeah.
Pay now, we're done. That's it, okay? Get the 90 days. You understand that?
I do.
Did you sign, read, and understand the advice of rights form here today?
Yes.
I'm gonna need for Jessica on this.
Jessica's out.
Yeah, I know. So just tell them whoever's available, probably. If you plead guilty, you're giving up all those rights and we're not going to have a hearing. Do you understand that? All right, to the charge to be able to refrain from consuming alcohol or drugs, testing positive for marijuana on October 16 of 25. How do you plead?
Yes.
Did you test positive for marijuana on October 16 of 25?
Yes.
Had you consumed marijuana, say within a week preceding that date?
Yes.
Anybody forced you to plead guilty?
No.
Your plea is accepted to that charge. There's only one count. You only had 2 prior technicals, but again, because this was an absconding, she could get
Understood.
90 days. All right, let me check something here before we're gonna get probation in here. What kind of controlled substance was that again? It's not on the citation.
That
Why didn't she show up here? Can you tell me?
Judge, she just became nervous and overwhelmed. I had a good deal of time talking with her, and she has tremendous responsibilities. She is the mother of 5 children, and she lives,
Are you married? She married?
She is not married. She is living with her fiance. She's essentially a stay-at-home mom.
How many children have you had by how many?
It's just 5 children with this gentleman. So,
Okay, you just haven't been married,
Yeah.
but you live with her.
Yeah. I'm sorry, Steve.
who gets married anyway these days? Although I believe.
But wait, you know.
I'm taking the fifth.
Look at it, that's-
I'm not waiting.
No, but
All
no,
right.
Judge. She suffers from schizophrenia, PTSD, severe anxiety, major depression, or manic depression, and she's overwhelmed and she doesn't didn't have the courage to show up. And again, this is a situation where we're asking for mercy, Judge. She has been taking steps to take care of her mental health. She sees a therapist 2 times a month, in addition to a psychiatrist that's obviously taking her medications. And we're asking, in lieu of any jail time, that she be given additional probation. It's my understanding that she has a separate charge that arose Flat Rock, which was public intoxication. No, it was originally public intoxication. It was reduced to disorderly.
I think so.
Okay, it appears it was reduced to disorderly. That's a non-reporting probation, and anything that's given, Judge, I hope coincides with that separate charge.
Ms. Blount's your name?
That's what was patient, Your Honor.
Anything you'd like to say, ma'am?
I am looking.
No, I was asking her for.
Oh, sorry, Judge.
Just, I apologize for waiting for its time by not showing up and truly apologize.
What had she done and not done?
Yes, Your Honor, I'm looking at Miss O'Donnell's notes. She did complete 34 total hours of community service. I believe she was given additional hours of community service for her first violation, which was a positive chemical test as well. There's proof that she attended some treatment, but not completion. So there is at least progress towards treatment, but again, no completion. Testing is kind of what you see there, Your Honor, as far as her being violated with a confirmed positive on this violation and a prior violation as well. I'm not sure if monies have been paid. The last communication that Miss O'Donnell had with her was back in September 25, before I think Miss Matisse absconded. And I did not have a chance to look, but there is a note here that she was sentenced on that new charge in Judge Hessen's case on the public intox, but I did not get a chance to see what those terms and conditions were.
Okay.
Judge, she does owe money, but she has indicated to me that she's completed that other program, the counseling.
Who's Jerry Knudsen?
Thank you, Dan.
He posted, first of all, I need a first page of a register. And can you hold on? Yeah, but you never showed up on a case out of, Taylor, an assault case that emanated from January, that, let's see, I don't know when it occurred, but
Yeah, I didn't.
hang on one second. You got a warrant out of Taylor since January, I'm sorry, Lincoln Park, since January 12, 26 on an assault case, simple assault.
Judge, I was not aware of it, sir.
That was.
That was what?
Did you have that charge?
And you didn't show up and you got a warrant out for your
Trying to figure everything out. I called up there and they gave me the walk-in days that I can come in and do. To go figure that one out.
Take care.
Take care of like everything that I've been trying to do is to take care of everything. So I'm looking away from my 5 kids because I'm the only person that can take care of them. The dad has to work so he can make the money to take care of them. They don't have like a.
Judge, very briefly.
Let me just say this before we go on. I have no choice but to revoke her 7411 status and enter the conviction. Now I'm going to re-sentence her. I'm going to listen to whatever you have to say.
Judge, this is the way it's that I get where you're coming from. However, I mentioned, however, this young lady has so many issues that have to be addressed. And She needs more extensive counseling with responsible medications. I asked that you continue the 7411 status, Judge, because again, she's been overwhelmed. She had in addition to all the issues she's gone through, she had a mental breakdown in the past 6 months, which when her husband was off work, she went to live at a motel just to get away from all the stuff for about a week. So I hope you understand what she's going through emotionally. Again, she was wrong for what she did, but at the same time, there's extenuating circumstances. I mean, she's 28 years old, has 5 children, and is balancing. What a tremendous balancing act, Judge. That's all I'm asking for. And obviously, no judgment, sir.
Glad you got that in there.
I mean, that takes full responsibility for all my wrongdoings. I'm just trying to make it right now. And I'm sorry that I wasted your time, not on the man.
I don't worry about my time. I don't know why everybody seems to be worried about my time. This is what I do for a living. I'm not worried about the time. How many hours of community service has she done?
She's complete 34.
It shows a concerted effort to try to take care of things, Judge.
So if I send you for a drug test right today, right now, what am I gonna see?
Just my prescription from the
There's gonna be nothing other than that's which has been prescribed by a physician.
yes, sir.
But she did indicate the marijuana, Judge.
Why are you staying with marijuana if you're pregnant?
Well, no, I haven't smoked in the last couple of days, but
When did you come down pregnant?
I just found out like 2 days ago. I missing NLT and my.
I don't need to get too in depth on this, okay?
There's money like that would be what felt it. But I do not have the money to take the test.
What's your husband do? I'm sorry, your father.
He does construction.
Sounds like he's on the labor's council with the highway for this judge.
Yeah, we just haven't paid it without a DTE, so I know I don't have money today to just pay it. I'm sorry.
I don't want to get too in depth. Did you go to a mental health facility?
She did not go into a mental health facility. A friend of hers suggested that she go get away, not to do anything stupid, but to get away like a lot of people need to, and they're having a heck of a difficult.
How long were you in this hotel?
For like, look,
What did you do when you were in the hotel?
I just relaxed and like tried to figure out my life, you know, like I relaxed, like trying to get in my head, you know, I get overstimulated really easily. Just rather say the one part.
She's overwhelmed, Judge.
I don't need you to go into any more depth.
My schizophrenia was back up with it. That's as far as I try to go with that.
Why aren't you getting yourself some mental health treatment?
I work with a therapist twice a week, and I go to a psychiatrist once a month. Not twice a month, and then I go to a psychiatrist once a month.
How long you been doing that?
For the past, I did nice thing, but I got thwarted. But I quit for like a year. Then I thought I made myself better, but I obviously made myself worse. And I started writing. But so far, I've done therapy for like 4 years.
And how long, are you telling me consistently you've been at it 3 times a month between the two?
Yeah. Consistently.
When's the last time you went to either one of them?
My psychiatrist, I just seen him on the 8th, and my therapist, I just seen her on the May 22nd.
What is that?
I don't know what that was.
Sounds like a train, another train.
I think it was.
I'm gonna still revoke her status.
Thank you, Judge.
I'm gonna give you 4 days jail. I'm gonna give you credit for 4. You gotta promise me you're gonna keep going to those 2 though, okay?
Go to,
Yeah, the mental health treatment and your psychiatrist.
how can people swear to him?
You gotta get your life in order, okay?
I don't.
All right, that's it. I'm closing the case. You can tell your father of your children, I gotta think this through again. They changed everything. I think they get the whole thing back, Heather. Mr. Newsom will. I don't know, you know. It used to be 10% and they changed that and there are never enough changes. I just give them all the money back. I don't think we're supposed to keep any of that. Okay? So you can tell the father to call up to the court and he can dial extension. What's yours, Heather? 234 or what is it?
228.
671-0201. Can you write that down for her?
I am, Jeff.
Extension 228. You can talk to Heather and she'll tell him how to go about getting this. Okay?
Thank you so much, sir.
Good luck. Thank you.
Thank you, Your Honor.
Thanks. Jamie Antonia Williams Bay.
What started as a simple plea hearing quickly turned into a reality check the defendant won't forget. A young man appeared in court after being accused of damaging another person's vehicle. According to the case, he had struck and broken the victim's windows, leaving behind property that could have resulted in much more serious consequences. Through negotiations, prosecutors agreed to reduce the matter to a civil infraction. The defendant also paid restitution to the victim, and both sides reached an agreement before the hearing. But Judge McNally wasn't impressed. After reviewing the file, he looked directly at the defendant and made it clear just how fortunate he was. The judge told him that he should go buy a lottery ticket because he had received an opportunity many defendants never get. While the lawyers had worked out a deal, the judge wanted him to understand that breaking someone's windows and damaging property is serious behavior. Then came the warning. You better walk out of here and realize how lucky you got. The courtroom fell silent. Instead of facing a much harsher outcome, the defendant received a reduced penalty, a fine, and a chance to move forward without further trouble. But the judge promised one thing. If he ever saw him back in court again, he would remember him. For the defendant, the message was clear. Second chances don't come often, and wasting one could be the biggest mistake of all.